Tracy. I'm an adjunct associate professor in the City University of New York Research Administration and Compliance Program. I'm also a Washington, D.C. attorney and privacy advisor, and I am talking to you today about tips and suggestions for issues related to COVID-19 and data protection and privacy issues and how they appear in the contracting realm. So these tips and suggestions are meant to operationalize and help you become better contract negotiators and provide added value to your institution. The first tip I want to share is that there is a lot of litigation presently focused on the pandemic. And in the legal world, this has had primary impact upon liability indemnification clauses, force majeure clauses, and contract performance clauses and contracts. So as a contract negotiator or as a pre-award or post-award administrator, depending how that work is divided within your institution, you need to particularly pay attention to these three types of clauses and make sure that they are narrowly tailored and appropriately tailored to your institution. Not only do you want to protect the institution and the faculty member, but you also want to make sure that this project can go forward. So that is tip number one. Tip number two is in the area of privacy or data protection to ensure that any clauses you receive are clauses that are narrowly tailored to your projects and to the institution you are working at. For instance, and this rule applies regardless of whether you're talking about the GDPR, various US state laws such as the CCPA, other foreign laws and jurisdictional laws that may impact on privacy and data protection. So if you are drafting these clauses, to make sure that you draft them appropriately to your institutional guidelines as well as to your project. And if you receive them from other institutions, make sure that you can comply with the rules and regulations in an appropriate manner. For instance, with the GDPR in Europe, the initial inquiry you should have is whether your institution can, in general, meet the requirements of the GDPR. And from that point, the analysis carries to a deeper level. So that's the second tip I have for you today. The third tip is more of a general contracting issue, but it does tie in with privacy and with COVID-19 issues, and that is, do your contracting activities and your individual contracting skills add value to the institution. Everything you do as a research administrator should add value to your institution, and contract negotiation is no different. The last tip I want to share today is the fact that you should be creating a contracting pipeline at your institution that will build future sponsored research growth. By a pipeline, I often talk about terms of having non-financial contracts such as NDAs and teaming agreements and material transfer agreements to feed and create opportunities for funded contracts or funded agreements. And so that contracting pipeline really should feed from non-financial contracts to financial contracts, all the way over into accomplished work and hopefully into tech transfer and commercialization of the work that happens on campus. So that is tip number 4 today. At the end of the day, the issues we are all struggling with in terms of both the pandemic, COVID-19, as well as data protection and privacy, these areas provide challenges to the research administrator. but also opportunities. And since research administration is a field where you have to constantly keep your skills at a high level, these areas are great opportunities for you to build your skill in, add value to your institution, and protect both the institution and your faculty member. Now, I think regardless of these issues, all research administrators in Ancura could meet the challenges of the pandemic and the rapidly changing data protection and privacy laws. That I have much confidence in. But it is an exciting time, and I wish you the best of luck. Thank you.